Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau with the Mineola law firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we have a special program, and attorneys can also earn CLE by listening to the program. You'll get details shortly on arbitration agreements, how they can be important to lawyers, their clients, and the general public. And my guests for today's programs are Elan Weinreb, who's the principal of his own firm in Garden City, the Weinreb Law Firm, and also Anna K. Mitchell, who's with Redmond Law, located in Manhattan. And Anna devotes her practice to arbitration, and she also has a master's in laws in arbitration and dispute resolution. And Elan is very involved with the Nassau County Bar Association ADR Committee. Welcome to Law You Should Know.
Thank you, Ken, for having us.
I know you have a lot of interesting points to cover. And again, attorneys can earn credit by listening to the program. We'll give you a special code and more details later in the program. What happens when people sign arbitration agreements?
Well, when anybody signs an arbitration agreement, they have to understand that to a certain extent they are not necessarily sacrificing, but they are compromising or taking a position on certain rights that they have. Whenever a person does end up getting into arbitration, which we should define what it is, arbitration's a private, confidential, alternative dispute resolution process that's similar but not identical to litigation or going to court, that involves one or more neutral decision makers. Those are the people we call arbitrators. Or arbiters. The process is such that the arbitrators or the arbiters have a certain measure of control over the process, such that the person who would be signing an arbitration agreement is giving control over to those arbitrators to resolve their dispute.
And did you want anything to that?
Yeah, I mean, I'd just like to point out, I think a lot of people actually sign arbitration agreements and don't even realize that they're doing so. A lot of us have the tendency when we're trying to get a new cell phone or, car lease, et cetera, to just sort of skip to the end of the tiny font and really just sign our names on the dotted line. But, if you parse through and you're reading, you'll really see even, employment agreements, credit card agreements, all of the above really incorporate a lot of arbitration.
And when people or business owners sign contracts, sometimes they may be signing arbitration agreements. And I know that both of you today are going to point out some of the pitfalls and some things they should be aware of, even if they don't have a choice and it's not negotiable.
Yes.
Okay, so let's just move on. Tell us more about arbitration agreements and what they entail.
Okay, well, an arbitration agreement, and just to give your listeners a heads up, if anybody wants more information on arbitration agreements or alternative dispute resolution, you could contact myself or the Nassau County Bar Association at 516-747-4070. They have arbitration and mediation panels. But what arbitration entails, getting back to your question, Ken, is the ability to resolve a dispute in a way which saves costs, time. It is speedier. It's certainly faster than going to court. And it's also confidential, which is an important point. It's not something which is exposed to the public. So when a person signs up for arbitration, he or she is gaining a lot of these advantages. And Anna has a nice way of describing arbitration as a bespoke trial.
Yeah.
Anna,
absolutely. I mean, what you can really do with an arbitration agreement, and that's why it's a very useful tool for business owners, who really want to be able to take a little bit more control over the process of resolving disputes, whatever they may be. An arbitration provision really allows you to select, the cost in terms of picking what kind of association you actually want to hold your arbitration through. It allows you to determine the amount of time, how much you're going to go into a discovery process. So it can really pick up the speed and allow costs to be evaluated more.
And also gives you control over scheduling. Mm-hmm. In court, the judge is going to tell you when you have to be there and what you have to do. in arbitration, there's going to be more flexibility to work it out for mutual convenience.
Absolutely. You can give a time frame initially and say we want all parties to exchange documents within 2 months, for example.
Or when the hearing will be held.
Absolutely. Yep.
And actually, arbitration in some ways is very much in the popular conscience because we have a variety of television programs which people think are representations of court proceedings, but they're really not. If you ever see The People's Court, for example, or Hot Bench, those are two very popular shows right now that are really arbitrations. They're not true litigations or true small claims court disputes. You even see that from the introduction to The People's Court, which I pulled off. Both parties have agreed to drop their claims and have their cases settled here. It's not that they're settling their cases, they're really just having them arbitrated by a neutral third party in a confidential forum, although it's not confidential anymore because everybody sees them, but that's their choice.
Go ahead.
And that kind of just leads into the point that when you're looking at these agreements, there are a whole different range of sizes for arbitration clauses. So that's something.
What are the most important things that someone should be aware of?
Well, one, that it's actually there, and then two, the extent to which the clause actually provides for how the arbitration is going to be held. So, that's something that Elan might address a little bit in terms of the simplicity or the complexity. And
yeah, there's varying types of agreements and clauses that we're going to get into, but just to give the world here an idea of some of the variables that go into any specific arbitration agreement, there's a program that is run on the AAA, the American Arbitration Association website, called Clause Builder, which I do not recommend you use it yourself. You should have an attorney if you're going to be using this to create an arbitration clause. But just to give you an idea of the types of variables or things that go into the agreements, you have the type of contract or dispute that is going to be involved with the clause, whether or not the dispute to be arbitrated is going to be an existing dispute or a future dispute, whether or not what Anna was referring to before, you have a simple or a complex arbitration clause, meaning do you have other procedures, preconditions, such as mediation, which is a different dispute resolution process than arbitration, before arbitration. The number of arbitrators are involved. Do you have one? Do you have three? Do you have more? Do you have less? The method of arbitrator selection, what sort of strikes do people have against the arbitrators? Are you going to follow the rules of a provider like the AAA, or are you going to have your own system? Arbitrator qualifications. Does the arbitrator have to have a specific type of expertise in patent cases or IP cases? You have the provisions dealing with the arbitration takes place. That's locale, governing law, what specific law would apply, discovery, whether you're going to have some sort of depositions or other type of discovery process, and maybe derogatories between the sides. And derogatories are rare, and depositions are also rare, but certainly document exchange is very much common in arbitration. Is it the hearing that would be involved in arbitration going to be a documents-only hearing, or is there actually going to be testimony by the parties involved? The duration of the proceedings, how long they're going to go for, what remedies are going to be available to the parties. For example, sometimes people have limitations on punitive damages. You find this very often in Better Business Bureau arbitration. The assessment of forum fees and attorney's fees, who has to pay what and when. The opinion accompanying the award, what type of opinion is it? Is it going to be detailed? Is it going to be simple? There's even provisions regarding confidentiality with respect to what the parties can say regarding the arbitration. Obviously, as I said before, in the People's Court, people are more open there, but in other arbitrations, things have to be kept under tight wraps. There is provisions dealing with non-payment of arbitration expenses. Unfortunately, people suddenly decide that they're not willing to go forward with the process. They stonewall. What then happens to the whole process? Can you go forward? Can you not? And last but not least, the last variable you have from over here is appeal options. Can the parties take an appeal of an award internally within the rules or frameworks set up by the provider, or outside of that framework? So there are a whole bunch of variables here.
And anything you'd like to add to that?
Yeah, well, given all of these factors, when you're looking at these agreements, they can be really simple. It can even just say the parties must submit to an arbitration. It might not even specify the forum, the time frames, the number of arbitrators on your panel.
Is someone better off, whether an individual or business, if there are some more details?
It completely depends on the nature of the business, and that's definitely a very big reason for why you want to be working with an attorney in terms of structuring your agreements.
Especially if enough is at stake.
Absolutely. And that's the thing at the end of the day, too. As a business, you need somebody who's going to help you really anticipate what kinds of disputes you might have in the future, and then how incorporating dispute resolution provisions in your agreement is actually going to play out in the long run. So, for example, if it's a more complex, multi-tiered provision that might require you to submit to mediation before you can actually go to arbitration, you really want to think okay, were we going to just be stalling the process of getting to arbitration by going to mediation because we're obviously at the point where we're not able to reach some sort of resolution? So looking into the complexity level of the clauses is very important.
Do you think that's a big negative to have mediation before arbitration?
I don't personally think it's a big negative. I think that it just depends on the nature of the dispute. And, the timing and effectiveness of some dispute resolution processes is really dependent on the nature of the case.
Okay. And one key thing, and I think it was mentioned, is the arbitration agreement may or may not specify who the provider is. And if it does specify a provider, you're bound to their fees and also their rules of evidence and their procedures.
Right. That is generally correct. Just to point in general, in most arbitration forums, the rules of evidence do not have to be strictly adhered to. You can obviously alter that by agreement, that the proceedings would be conducted like you would have in court with various hearsay rules and what else applicable. But more often than not, it's usually the case that the rules of evidence are relaxed.
Right, but the provider's rules might detail to what extent they're relaxed.
Correct. In other words,
Absolutely.
that usually involves considerations regarding weight of the evidence as opposed to admissibility.
And even whether an expert has to be there in person or their written reports can be submitted, which can make a difference in the expenses. What about counterclaims? I mean, when you go to arbitration, you're giving up your right to a jury. In most cases, giving up your right to appeal. It's going to be binding. What about counterclaims? If you were sued, normally you'd have a right to bring a countersuit. Your countersuit has to go through arbitration.
When you submit to an arbitration agreement, you are essentially waiving all ability to go to court except for involving disputes as to whether or not you are subject to the arbitration provision.
But
so
can you
when
bring
you're
a
there,
countersuit within the arbitration?
Absolutely.
But you then have to pay fees if there's a fee clause based on the amount you're suing for.
It completely depends on the organization that you're working
But
with.
it's something to be aware of, that it could be a hindrance. And also the fees can be a hindrance. If a person go to court for very little money, and except for the legal fees, but there are very few administrative fees. Arbitration fees, you're paying the lawyer, but you're also paying perhaps half, perhaps more of the administrative fees and the arbitrator's time. The judges are working for free. They're paid by the government. So it's just something in a smaller matter, or if you're involved in a small business or individual, it's just something to be aware of.
There are a lot of factors to consider, and that's absolutely why you should work with the lawyer.
There's also this situation, though, sometimes where people bring counterclaims and they're not within the scope of the arbitration agreement, in which case you'll have fallout or spin-off litigation regarding whether or not those counterclaims really should be arbitrated. And if people are interested, you could take a look at the case Fujifilm versus Gillespie Mill Enterprises that started in the Eastern District in New York on March 9th, 2017. You'll see some of those issues are present in that case.
And can you tighten up the language in an arbitration agreement if you so choose so that any and all counterclaims would have to be brought in? Or
Absolutely.
Just only counterclaims which are the subject of the contract?
I think that's kind of the amazing thing about this process is how much you can really design how you want the arbitration requirements to function for you.
And so it's basically a contract issue. That's part of the contract, and that the wording or the lack of clarity in the wording can be very important down the road. And that's another reason you need a qualified attorney.
Yes.
To
Absolutely.
review it and draft it and understand your options. We're going to take a short break now. When we continue our discussion, we'll continue our discussion in a moment about arbitration agreements. Our guests are attorneys Anna K. Mitchell with the firm of Redmond Law in Manhattan, and Elan Weinreb, whose principal is his own firm, the Weinreb Law Firm in Garden City, Long Island, New York. You're listening to Law You Should Know here on 90.3 WHPC. Also over the web at ncc.edu/WHPC. We'll be back in a moment.
This portion of programming on WHPC is brought to you on behalf of the Nassau County Bar Association, who wants you to know about ADR, Alternate Dispute Resolution, which can help you avoid costly, lengthy, and uncertain litigation in court. By resolving disputes through mediation or arbitration, it gives you control over who decides your case. A mediator helps all parties to reach an agreement they can live with, or an arbitrator selected by the parties hears and decides the case. Your attorney can still represent you, but you control who decides your case. ADR is faster and less stressful than fighting in court, and it is a great way to resolve divorce, employment, or commercial disputes. ADR is now offered through the Nassau County Bar Association. Find out more about how ADR can help resolve your dispute by calling 516-747-4070 or visit nassaubar.org.
Once again, we continue with Law You Should Know. From the Mineola Law Firm of Shane, Dox, Denise, Corker, and Sauer, here is attorney Kenneth J. Landau.